It is not unusual for lawyers to complain about the backlog of cases and the time it takes for them to be dealt with. However, former magistrate and attorney-at-law Tiani Behanzin is of the view that the situation can be dealt with if certain measures were to be taken. Behanzin spoke to CBN4 after a 4-year-old case he was involved in was thrown out of court on Tuesday at the High Court. And that case involved a young man from Casa Bruce, Lyndon St. Louis, who was charged with causing death by dangerous driving following an accident which resulted in the death of Corinne Francis. The fatal incident occurred in 2013 when St. Louis attempted to start a vehicle down a slope, and the victim, who was unable to speak or hear, was on the side of the road when the vehicle struck her. According to Behanzin, prior to the disposition of the matter, he tried without success on several occasions to have the matter disposed of.
In order to convict somebody for dangerous driving on the road, you have to look at the conditions of the road at the time, you have to look at the road users at that time, and the nature by which the person is driving. Now, reckless means that they have almost no control. If he's taking positive action, clearly he's trying to avoid her. The second thing is that because she had that condition, she was not able to hear any of the actions being taken by the driver to avoid hitting her. And then secondly, it appears that there was something in the medical evidence that suggests that there may have been another condition that she suffered from, which made it difficult for her to have some sensory deprivations of some sort, which would make it difficult for her to be able to be aware of what was going on. So that was the issue. We had over the past 4 years tried to talk to all of the prosecutors involved in this matter. I think 2 or 3 of them had gone through at some point to try to show them that what we were trying to say. And it's only at the last day, I mean the day when the matter was brought for trial, the morning the matter was, we were informed that the matter was discontinued.
In recent times, a number of matters have been thrown out of court, either on a technicality or for want of prosecution. The cases of Denny Shillingford and Vivian Charles being 2 prime examples. However, Behanzin believes that this may not necessarily be due to any inefficiency on the part of the Office of the Director of Public Prosecutions, but rather the lack of resources within the justice system. He made some suggestions that could assist with the proper administration of justice.
I think we could do better with better trained and experienced magistrates. If we pay them more, maybe we might attract more and maybe of a different caliber. Secondly, they could be deployed differently. I think, for example, the former registrar, for example, could head a civil division of the magistrates court. He's just sitting at home. He's a fairly young man. I don't see the point of him sitting at home wasting time when he could be used. His skills, his experience could be deployed towards doing something like that. There are magistrates that have experience in finance, but yet they have them doing criminal work. So there's things that they can do to try and make things better. We still could do with another 5 magistrates so that the work is a lot more efficient, there's less backlog, cases are moving a lot faster, and people are going to be less tempted to do self-help when they have a matter in the court if they know the court will deal with it quickly. If it's a longer delay, people tend to be more on edge, and less patient.
The former magistrate stated that the waste of time and resources at the court puts further pressure on the legal system, something which the country cannot afford.